is a statement for workmen's comp, Judge Bill's court. I was heard on 3/21/2009, and I was on state disability on 4/17/2009 EDD. I was on state disability because I was denied disability payments, etc., on 4/17/2009, in which I had to hire an attorney because Esperanza sent me a letter denying me everything behind a PR2 report. A PR2 report that was not signed, properly signed by the company Dr. Patel and myself, which is required. There's no signature on a PR2 report, which is required, a signature, okay? So I'm asking Judge Brewer to consider I don't know, whatever he wants to do, but I want to make him aware that the fact there's no signature, proper signature, and it has been properly signed by either Dr. Patel or myself, and I knew nothing about the PR2 at the time, and I just received the PR2 report. Also, I'd like to note that on December 1st, I received a notice of offer of work, and I signed it, and I asked for Eureka run 10 o'clock in the morning, 14 hours a day, overnighter, and with seniority intact. I should note that they refused the notice of offer of work on more than 2 occasions, and the third occasion was in 2012 or 2013 when Mrs. or Miss Morles sent me a notice of offer of work that I received on December 1st, and it was deemed accepted. Whether I responded within 20 days or not, it was deemed accepted, and they took 15% out when I was working in 2010. So I was working the whole time, and they've been taking out 15%. And the fact is that they didn't honor their notice of offer of work because I didn't report to duty on my 10 o'clock shift, and they took 15% out, and they flat out sent me home on December 7, 2010. So like I said, on December 1st, I received a notice of offer of work 2010. On December 3rd, 2010, I went to work. On December 7, 2010, I was sent home, flat out just sent home. And I should also note that it's a union shop, and the fact that I asked for the 10 o'clock shift, that anybody works underneath me, according to seniority, I have to get paid for that day according to the contract. Anybody that works below me, I get paid for that day, and it's a 24-hour operation, 7 days a week. So I should get paid 14 hours a day for 7 days a week until I return to work. And this is January 19, 2013, Saturday. I should note that. And the fact that I haven't been paid every week or every 2 weeks disability payments. I've been on EDD, state disability and unemployment since 4/17/2009, and I received a letter of conflict of interest that Safeway is not, they don't have a right to decide anything, and it's ongoing. I just received another conflict of liability in 2012 or 2013. Again, stated that they're not allowed to decide anything, whether I'm on disability or not. I don't know what that means entirely, but I just like to Judge Bill to know that they're a conflict of interest. Okay, so we got that straight. And I was also on FMLA on December 7, 2010 when they flat out sent me home because they didn't want to order a notice of offer of work. Okay, on the union thing, I had a panel hearing, and that they put it in a bid, and they took me in the back room, and they wanted to know I didn't say anything. And this was in January 11, 2011. I remind the court that I was sent home on December 7, 2010. That's almost 1 year later, plus the fact that they had a panel hearing, and they took me in the back room, like I said, and they put it in a bid, and they wanted to know why I didn't say anything. At that point in time, I mentioned the fact that I had a hearing impairment, severe hearing impairment, and I mentioned to the 2 shop stewards and Mr. Nightmonger that were present that are they an authority on severe, profound hearing impairment. I answered registered mail, one to the union and one to myself. Long story short, the panel hearing was put in abyss. I was flat out sent home, and I never received any registered mail or anything else. And they didn't respond in 10, 20, or 30 days. According to the letter that I received from the union attorney and legal clinic, that I was fired on December 16, 2010. The union attorney did mention one fact that the discharge was denied on December 17, 2010. And he did mention the fact that Safeway did not respond by Christmas, December 25th, 2010, with any evidence or any document whatsoever to prove their accusations, whatever they may be. Okay? And the fact is that they didn't respond in 10, 20, or 30 days. And the point of all this is the fact that if they don't respond within 10 days, according to the contract, which they didn't respond 10, 20, or 30 days, according to the contract, it's null and void, final and binding. Null and void, final and binding. And I should also note that there was no representation when I was interrogated on December 7, 2010. There was no shop steward present, and that I had a hearing problem since 2009 or before, and they knew about it because I take a DOT physical every 2 years. And the box is checked. Hearing aids. So, that being the case, so the union attorney did mention the thing that about the panel hearing being in abyss because I had a severe profound hearing impairment. So, and I was waiting for a reply all this time, so I applied for arbitration, and arbitration was denied because the union attorney said there's no way we can win this case, and that we understand that you have disability issues, but we're not going to hear this case in arbitration, and that you can pursue it under workman's comp if you wish to do so. Well, I wish to do so. Okay, so now I'm in workman's comp. And I hired an attorney, which was Adam Stewart, on 4/17/2009. And we had a settlement conference, and the fact is that we had a hearing with Judge Grill, or whatever, and I presented a document from a hearing specialist that I had a severe profound hearing impairment. I was partly deaf, and that it was suggested that I should take sign language and lip reading. Okay, so that was that. When I went to the court, Adam Stewart didn't put anything on the table of Judge Grill courtroom, and there was no listening device, and there was no interpreter. And so I presented Judge Grill the severe profound hearing impairment examination, showing with a prescription that I was partly deaf, and that I needed hearing aids. At that point, Judge Grill suggested or ordered the two attorneys to give me a legal document for severe profound hearing impairment, to establish the fact beyond a reasonable doubt that I have a disability, a certificate of disability that I'm deaf, that I have a permanent disability. Now I remind you that I received a notice of offer of work on December 1st, which they didn't honor and sent me home on December 7, 2010, flat out, just sent me home, and took 15% out, and I didn't work one day on my 10 o'clock in the morning shift, Eureka run. Okay, and there's 200 employees underneath me, like I said before, so the work was available. There's no problem with that. Okay, back to the severe profound hearing impairment. So I took a test the other day, and there's no doubt that I'm deaf. I was deaf when the dispatcher interrogated me, and the dispatcher falsified or altered my log to December 6, 2010, and did not make me aware that I lost 20 minutes. My logs were not balanced. They didn't tell the truth because he altered and falsified my logs. So my logs weren't correct, and I didn't sign no log correction to be true and correct. So he took the time from the data machine and the driver's room and changed the time on my logs. He took 20 minutes off, which I started at 10:30. I was working at 10:30. Now 20 minutes was shy, and my logs are not complete. They're wrong. I took them to the DOT logs, I took the time from the data machine in the driver's room, in which we're already on duty when we come to work, but according to him, I guess I was not, for whatever reason. But I followed company policy and union contract, which has instructed us to follow DOT regulation, and I did so. So in any event, on December 6, 2010, he altered my log. On December 7, 2010, he did not make me aware that he did that, and there was no shop steward present when I was interrogated, and I was flat out sent home. And I was not fired on December 7, 2010, and I was on FMLA. I should also note that Patel, that Esperanza took me off of disability and denied me everything behind a PR2 report that was made out by Dr. Patel in Tracy, California. And I should also note the PR2 report is not signed. If I'm repeating myself, please excuse me. I just want to make it clear that the PR2 report does not have his signature or my signature. They're required to sign it first and last name. Okay? They're required to sign it, not initial it. It says required to sign it. You need to read the bottom of the PR2 report as it's instructed. So I'm asking Judge Bill to not accept that PR2 for its full value because they didn't follow procedure. And the PR2 report is not telling everything because of the fact that I ended up in the hospital on 4/5/2009. I came out of the hospital on 4/6/2009, and I went to see, I'm not quite sure, I stand to be corrected, I think it was Dr. Hubby or 4/8 or something like that, and I gave her a copy of the MRI report stating that I went into the Los Banos Memorial Hospital with left leg pain, and they took an MRI on 4/6, and I came out with low back because they couldn't find out what was wrong with me. There was something terribly wrong with me. And so they came out and made an occupational report, Los Banos Memorial Hospital, and their statement is that I have a low back according to the MRI, in which Dr. Patel did not mention in the PR2 report. But in any event, I hope Judge Bill considers the fact that I'll make that PR2 report invalid because it hasn't been signed by me or Patel. A complete signature, which is required. Back to the notice of offer of work that was denied at least 2 times. And the third time was a letter was sent to me by Mr. and Mrs. Morales, Safeway Private Insurance in Arizona, saying to sign and complete the notice of offer of work and please send it in, which I did, registered mail. Start time 10 o'clock in the morning, Eureka run, 14 hours a day, and I sent it in, and my attorney sent me a letter saying to report to work immediately. I called Mike Sadler, and I said I'm ordered to report to work by my attorney, and he said he don't know anything about it, and he's not putting me back to work. And I should also note that the union, the same thing, okay? Even though they had the permanent abyss, and they didn't acknowledge the fact or took the fact serious that I had a severe profound hearing impairment. In any event, the judge, like I said before, ordered the 2 attorneys to get me a legal document, and I just took the test. I took a hearing test, a legal document, certification of disability, which I signed. And I hope to receive a copy this week or next week. And the attorney at Legal Clinic will also receive a copy. I called there and they told me that they were going to send me a copy. So going forward with this, now we know that I'm legally deaf. And now we know that the union did nothing about accommodating me with a listening device, even though they said that Nice Morgan said he would pursue it. He would look into it, but it was never got back to me. Not until a phone call in 2011 or 2010 or before that there was going to be a panel hearing on January 11, 2011. And I should know that's not within 10 days or 20 days or 30 days from December 7, 2010. They didn't respond 10, 20, or 30 days, and they didn't put me back to work like they did 1,500 other Teamsters. If it's not filed within 10 or 20 or 30 days, they are put back to work immediately with no questions asked. Well, that didn't happen to me, and I don't know why. And I don't know why that the man, the dispatcher, that falsified or altered my logs and did not make me aware of the fact that he did it, is working and I'm not, and he's the man that sent me home. And that's very serious. He's working and I'm not. Or he was the cause of sending me home, whatever the case may be. But the fact is, the union or the company did not do anything in 10, 20, 30 days. They didn't produce one document or one odor of evidence that I was guilty beyond a reasonable doubt. I was guilty beyond a reasonable doubt. They did nothing until 2011 when I had a family hearing, and they put that in fence, and that's it, sent me home. And the notice of offer of work was never honored, all the way up to 2013. So we know that also that I was on FMLA on December 7, 2010, and there's a notice of offer of work which says that I can have prescription drug according to the QME report, that I'm allowed prescription drug, muscle relaxers, and that I can do my customary duties. They made an agreement with Workmen's Comp in October of 2010. They made an agreement, a notice of offer work good for 1 year. They guaranteed me work for 1 year. Well, it didn't happen, and they took 15% out, and they kept taking the 15% out, even though I didn't meet my 10 o'clock in the morning shift Eureka run. They did. I worked the whole year up until December 7, 2010, because I received the notice of offer of work on December 1st, 2010. And in 2009, on 4/17, I was denied everything I had to file with the unemployment office, EDD. I know I'm repeating myself, but I want to make it clear that I'm asking Judge Bill to not accept the PR2 report because it's invalid, because there wasn't a proper signature, and my name wasn't signed. I did not sign that report. And Dr. Patel did not sign first and last name on that report, so I'm asking him not to accept that report. Okay? So there's a lot of discrepancies there, so we don't need to go into that. The fact is, they sent me home because I received a notice of offer of work on December 1st. And then later on, they knew from 2009 or before that I had a hearing problem. And the reason I was sent home, it wasn't because I was deaf. It was because I received a notice of offer of work. And later on, the judge ordered a legal document, and then when I took that test more than 2 or 3 weeks ago, I found out I was legally deaf, and now the union has a problem because they have to hear that panel, complete that panel hearing. Complete that panel hearing, and you simply have to produce 2 registered mail. 2 registered mail, and they haven't proved their case before Christmas in 2009. So what I'm saying is they never responded in 10, 20, or 30 days. According to the contract violation, null and void, finalized binding. And 1,500 Teamsters are put back to work immediately, if not within 10, 20, or 30 days. There's no doubt about that. And then I'd like to make it clear the union said I could pursue this under Workmen's Comp because they're denying the arbitration because they can't win it. So that's my statement for the court. And the fact that no one had a hearing test, a legal document ordered by the court. The last time I had a Workmen's Comp hearing, he canceled it because I didn't have an interpreter or a proper hearing device, and I gave a document showing that I was deaf, but it wasn't a legal document. So yesterday I took the examination, and there's no doubt that I'm deaf. And the damage is already done. There's nothing to be done about it. In fact, it's getting worse. It's ringing off and on. According to the doctor, and he said, yes, I should wear earbuds. but I can't wear earbuds if I'm driving my car, right? Until I get some hearing aids. The hearing aids I got, they work and they don't work and they're really old. They're just really old hearing aids. They'll work for the meantime, off and on, but that's all I need is I barely passed the test, and so I can work. There's no problem about going to work. I have a valid license and everything, so there's no reason why they can't put me to work. There hasn't been. Okay. So anyway, it would take 2 or 3 weeks for the report to come in, but the fact is I'm deaf. That's the bottom line. And that's not the reason why I was sent home on December 7th, 2010. It wasn't because I was deaf. It was because I received a notice of offer of work on December 1st, 2010. According to the QME report, I could do my job, in other words, okay? Anyway, they sent me home flat out on December 7th, 2010. And me being deaf then has nothing to do with them flat out sending me home. At least I don't think so. I won't know until we go to court. And I should mention the fact that I had a panel hearing with Safeway in 2011. A nice one. I had a panel hearing, and they stopped the panel hearing. And he took me to the back room, and he wanted to know why I didn't say anything. And I told him that I have a hearing impairment. I have a severe hearing impairment. And he said, well, that's the first I heard of that. But that's not true. My wife knows that I told him that I have a hard time hearing, and that I don't recall exactly, but I'm sure that I mentioned the fact that I had a hearing problem since 2009 or before. But in any event, I told him and the 2 shop stewards that were present that I had a hearing problem and this and that, and it was a big issue. I don't know what to say, and then I was talking to the shop steward, and I told him, are you an authority on profound hearing impairment? And he was just stunned. He didn't say anything. So the panel hearing was in a fist, and they just flat out sent me home. They never sent me any registered mail in 2010 about my situation, and I called them before Christmas, and Safeway never responded in 10, 20, or 30 days. Nothing. Okay? And I told him I had a hearing problem. It was a nice one, but he said he's going to talk to Safeway about it, whatever. He's going to pursue it, right? Well, they sent me home, and I never heard a thing from them. That was the end of it. And then, so now I'm bringing it up now because the judge in workman's comp said get a legal document. Now I've got 2 documents that say I was deaf. 2 documents. Okay? And so anyway, the union attorney sent me a letter that they're going to deny me arbitration, and I could pursue it under workman's comp because their understanding is I have disability issues. And they're not going to go to arbitration. And if I want to pursue it, I can do it under workman's comp. Now, they just finished the panel hearing, and they just dumped me right out, and they didn't follow contractual procedures, and then this guy here falsified my documents and everything else, and didn't make me aware like he's supposed to, and the fact that I was deaf, and I asked for a shop steward to be present or somebody to explain to me what the heck's going on, and nothing was done. And there was a lot of drivers in the driver's room. They even asked me to go, what's going on? Why is this guy throwing his hands up in the air? And I got tomorrow and all this stuff. And I didn't understand a damn thing he was saying. I had no idea. I told him, I don't know what you're talking about. Man, what's going on? But the fact that he didn't make me aware that he altered my logs or changed the time I logged, according to the data machine in the driver's room, which doesn't have a time code, it doesn't do anything. I mean, we're already on duty, but he's saying I wasn't on duty, but the Department of Transportation, the federal government said I was. So who's correct? I have no idea. I just followed DOT according to the contract and according to company policy. And that's what I did. And when he was yelling about, I don't know, okay? off the property of Safeway. It's like he just flat out took off. He just whispered it and just took off, whatever he said. So, that's it. I was deaf. I received a notice of offer of work on December 1st, which they held it up since October. My agreement made with workmen comp to work me for 1 year. We don't have to go through all that. But the point is, they need to be returned me to work because of the notice of offer of work guaranteeing me 1 year of work. Okay, but now we find out that I'm legally deaf and I have a legal document, so that puts the union in a bad position. I would think so. I don't know for sure until I go to an attorney, because I have a document from the union attorney stating the fact that we're not going to hear this case in arbitration, okay, because we can't win this case. That's what he said, okay? And that was it. They sent me a letter saying I was fired on December 16, 2010, but he didn't mention a word about it being denied on December 17, 2010. And he didn't mention a thing about the family hearing that I mentioned, that I had a hearing impairment, not as longer. The attorney didn't say one darn word about that, but he did say that they were aware of the disability issues, and I sent him documents that I had a hearing impairment. I did everything I could. I responded in 10 days and everything else, but that wasn't acceptable. So I have a legal document. The union is wrong, and Mr. Nicemonger, he better get out of that bed he is with Safeway and get me back to work. Because I have a legal document that says I was deaf and I didn't understand what was going on at the family hearing, and I didn't know what was going on when the dispatcher had me escorted off the property or whatever it is, and he falsified my documents. There's no doubt about it. Okay? So I'm innocent. There's no doubt about it. I have legal documents now. And that was ordered by the court in workman's comp. So, I don't know what the union's going to do, but I know there's a nice one. They better file a statement and everything and complete that panel hearing. Because, Safeway's wrong. They're wrong. They're guilty. They need to be returned to work like 1,500 other Teamsters. Because they didn't respond in 10 days, 20 days, or 30 days. And if James Williams, the terminal manager, he knows this. And why isn't he putting me back to work? I don't know. Is it because I'm deaf? Or what is it? Because he didn't honor the notice of offer of work. And then the dispatcher took my time card or my log sheet or drip sheet or whatever, and everything and threw it in the garbage because I didn't get paid for that day. And he's working and I'm not. And he's not deaf. He's supposed to burn my laws. It's not supposed to do that. Now he broke the law. That's a serious thing. And why is he working and I'm not? And I'm the one with the permanent disability according to the QME report. And I can do my customary duties so that I have a permanent disability. There's no reason why I can't work. I didn't do anything wrong. So, I don't know how I'm going to, I don't dare call Nicemonger because I don't know what, I think that's just a lost cause. I don't know. I'm going to put this on the internet. I don't know what's going to happen after that. Maybe he'll hear about it. I hope he does. And then maybe he'll go ahead and file agreements or whatever the union attorney decides to do, but they're all wrong. They got all their facts wrong. I thought they were supposed to have an investigation. What kind of investigation is that? They didn't prove any evidence. They didn't do nothing. And they violated the labor code. And the fact that they had a legal document, that's not good. They definitely violated the labor code. So, and they violated contractor procedure, and they violated workman comp rules and regulations. Now, I'm not the one that decides whether they did all of that. It's up to the judge, but I'm thinking that they did. So we won't know until we get to court. And the fact that legal clinic will get a copy of that I'm deaf, and plus they have the notice of work that they're looking into. That's what they said, but the attorney sent me to work, and they, he just said, I don't know anything about it. And the union said, well, I don't know, it's first I heard of it. Every time I turn around, I go, I don't know anything about it. You're understanding that it's a wasted time for me to be going there and calling them and say, hey, you need to put me to work and this and that. And just a waste of time. He took my lifetime medical away. I got my daughter needs one more year of college. And oh, Jesus Christ, man. You know, so I hope your workman's comp judge, you know, gives me that automatic retirement on my birthday this year. Automatic retirement with a letter saying that I'm retired for Safeway and that I have a permanent disability. You know, because I can't work there any longer after all this. Because they need to pay me from December 7, 2010, back paid benefits, 14 hours a day. Eureka run, which that's what I asked for on the notice of offer of work. That's what I asked for. I didn't start my 10 o'clock start. I never worked one day on the 10 o'clock start. And they took 15% away. And now I'm deaf. And they haven't paid me disability payments every week or every 2 weeks. So what's going to outcome of that is I don't know. But they need to put me back to work so I get my lifetime medical. There's no reason for them to keep me off work. Not one. Nothing. And the guy that falsified my documents, I don't know why he's working and I'm not. Okay, because I didn't do anything wrong. So if he should work, I should work. And if 1,500 other teamsters are put back to work because they don't file agreements or do whatever within 10, 20, or 30 days, they're violating step 1 and step 2, null and void, filing binding. So, I think the union attorney better clean this up and look into it because there's no doubt if the union doesn't get me back to work, I'm going to go to an attorney. I have to. And I don't want to. That's not what this is about. It's about 2 children going to the university. That's what this is all about. It's not about trying to work longer because they're going to be 73 years old this year. It's got nothing to do with that. Nothing. It's about getting 2 kids through the university. That's it. So they have a chance in life, and I can get that under my belt, and I'm going to feel good about it. Did I, did all I could so that my children will have a chance in life. Yeah, I'm going to feel good about that. You know what, to be honest with you, I'd love to retire, but I have responsibilities. I have responsibilities to my family, to my children, and to myself. You know, I mean, they're children. They need a chance. For Christ's sake, this isn't about trying to make more money. I'm happy with what little I have with my Social Security and everything. I don't know what they're saying about me. I'm rattling off because I have no idea what they're saying. I know they're attacking my credibility, and I don't care. They can attack it all they want. It's not true. But hurting my family and me like this is not right. It's wrong. You know, and I gotta get my son. Jesus Christ, he needs help. And my daughter needs that last year, so I'm fighting back, okay? And I know, like Adam Stewart said, you guys are stubborn. No, I'm not stubborn, just standing up for my rights. I'm standing up for my rights. Do I have any rights? I'm innocent. I'm innocent. And do I have any rights to stand up for my rights if I'm innocent? Or it's just already decided and that's the end of it? No, that's not the end of it. You don't just go hang somebody or electrocute somebody because they're innocent. They got a right to speak up. They got a right to stand up and prove that they're innocent. Well, I proved I'm innocent. So why am I back to work? And because I know they got investigators out there, and they know I'm innocent. No matter how they look at this thing or flip it around or try to twist it, it's just not going to matter because I'm innocent. I got legal documents that show I'm innocent. I should be working. And I know they don't want to pay that back pay, but they're going to have to pay it 14 hours a day, 7 days a week. That's right, because anybody that works underneath me, according to the contract, has to pay me for that day. And now they put themselves in that position. The dispatcher screwed up. James was the transportation manager screwed up. And my senator screwed up. They all screwed up and the union. another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morality unfair suspension toward a certain group of the principle that all are equal in their freedom. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standard also violates the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social, class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase, "life is not fair," may be invoked in order to mollify concerns over double standards. There is a distinction to be made between double standards and hypocrisy, which implies the stated or presumed acceptance of a single standard a person claims to hold himself or herself accountable to, but which in practice may be disregarded. Being hypocritical to the double standard is then a positive example of hypocrisy as well. Though the term double standard is of relatively recent origins, the concept expressed by it has existed in various cultures from far earlier times. For example, Jewish tradition has interpreted in this light the biblical injunction in Deuteronomy 25:13-15. Do not have two differing measures in your house, one large, one small. Do not have two differing weights in your bag, one heavy, one light. You must have accurate and honest weights and measures, so that you may live long in the land of the Lord, your God, is giving you. The modern Hebrew term for double standard is derived from this biblical verse, Ephia v. Ephia, literally two differing measures. In the interest of justice, I hope that Judge Will considers this. So, I, Julio Zamora, invoke double standards. Life is not fair.
I hope that Judge Grill will consider this in his decision on returning me to work.